Well, good evening. This is Karen Harding. Today it's 9:04 p.m. on Tuesday, the 14th of April 2015. Tomorrow, on the 15th of April, I'm leaving to fly to Christchurch. On the 16th of April, we have our major hearing for the Oyang crew seeking relief from forfeiture of Oyang vessels, Oyang 77 and Oyang 75. We are seeking unpaid wages for an amount of over $5 million that has been unpaid by the Sajo Oyang Corporation, who have enslaved my clients by not paying them the New Zealand minimum wage. We are arguing that the case of Idea Services Limited versus Dixon applies, and that for every 24-hour, 7-day-a-week period each of my clients spent on the vessel, they are entitled to be paid the New Zealand minimum wage for each and every hour. This is because they were at the beck and call of their employers for every hour of the day, under circumstances in breach of the New Zealand Minimum Wage Act 1983 and in breach of Section 12A of the Wages Protection Act 1983. This is in relation to contracts being signed in Indonesia, where the clients were required to put up security to obtain jobs in New Zealand on South Korean fishing vessels. This included security such as land, which is over houses, paddy fields and the like, as well as vehicles. And if the client did not have their own vehicle, they had to put up the vehicles of their neighbours. In one instance, a person had no security at all and put up the mosque leader's property. In addition, they were also required to put up items of value. So for some poor people, all they had was their graduation certificates from elementary school. It's very hard to pass elementary school in Indonesia because it's very difficult to get the money to go to school. Those are things that are irreplaceable. In addition to that, they had to pay salaries to the Oyang Corporation as what they call security. So they signed agreements in Indonesia for wages of approximately between $200 US per month up to $290 US a month. This is grossly in breach of the Minimum Wages Act 1983. Now, in addition, they were required to pay fees to the agent to get the jobs. The fees were around 2 million, 3 million Indonesian dollars, which is their rupee actually. So in relation to that, they were putting up fees of over 2 months worth of their wages or longer. In addition, salaries were held for 3 to 5 months from the moment they went on the ships in Indonesia to work. That means their families got no money at all for 3 to 5 months. Then going on to the end of the contract, which is for periods of up to 2 years, wages of 30% or more were withheld. So for some people, for example, on a minimum wage under the Indonesian contract of $220 a month US, their wages were reduced to $170 US a month, and the hours they were required to work were excessive. They were working between 18 hours a day, 20 hours a day, 22 hours a day, and in some instances they were required to work more than 24 hours in a row and sometimes more than 48 hours in a row, particularly those involved in processing fish and working on the deck. In addition, they were required to live in abject poverty in rooms on these vessels that were full of cockroaches, mice and lice. The bedding was filthy. Also, bedridden with insects. They were bitten in their sleep. They were also subjected to abuse, physical assaults from the captain and the officers, and sexual harassment and sexual abuse for some of the clients on the vessel, solely by the Korean officers abusing their power. This was working conditions. In the meantime, they are also working very hard to try to catch and process quota fish, while the ship is overfishing and breaching New Zealand regulations. What has happened is that the captain and the officers have been prosecuted in relation to fishing crimes in New Zealand. The vessels Oyang 77 and Oyang 75, after the conviction of their captains and associated officers, have now been forfeited to the Crown. Oyang has applied for relief from forfeiture. They would like their boat back. Currently the boats are away overseas, but they are being held with a sort of an order over them that they can be brought back at any time should the court decide that they need them back. And also they've been required to put up a bond of $900,000 to guarantee that they will bring these boats back. What we are seeking is for our clients to be paid their wages, and not just any old wages, the full maximum entitlement for what has happened to them. That is, for every hour of the 24 hours, the 7 days a week of the 2-year period that they were forced to be on this vessel. Because what's happened is this is not an ordinary workplace. What has happened is this is forced labour. This is debt bondage. This is human trafficking. This is enslavement. So on behalf of the 26 applicants, we bring to the court the following documents. We are bringing a civil action. This is our statement of claim. It is quite extensive. It has 16 sections, as you will see here, and it has schedules going all the way to Q. It sets out to deal with the material times that this happened. In relation to this application, we are talking about a period of time between the 13th of December 2007 and the 20th of October 2011. We have identified the forfeited vessels. We have identified our interest in the vessels under section 2561B subsection 2 of the Fisheries Act 1996 over Oyang 77, over which 24 of the 26 applicants worked. We are also seeking relief from forfeiture in relation to Oyang 75 under section 2561C in relation to having an interest in relation to unpaid wages that existed prior to the vessel being forfeited.